Okay, thank you very much. I hope that we're all patient and to cope with the technical difficulties that some people may be having. By way of introduction, I'm Samuel Okoronkwo, and started life as a quantities surveyor, became a construction and development project manager before finding myself in the law and becoming a barrister. Unsurprisingly, I specialize, amongst other things, in dealing with matters in the built environment. It covers planning as part of what I do on a daily basis. So what we're going to be discussing today is a subject matter that I work on day in, day out. So as a barrister, I help clients with contentious planning disputes, assisting them where necessary in challenging excessive Section 106 and CIL demands, assisting in reversing planning objections, dealing with planning appeals, and of course, reversing planning contravention notices in circumstances where clients have been unfortunate enough to be at the receiving end of that. Now, one principal point that I would like to make at the outset is that, like most things in life, contentious planning is all about adequate preparation. Now, if you engage in contentious planning issues, the golden rule is to anticipate the issues that are likely to arise in the course of your particular planning, and then being able to articulate and then make your case robustly. Invariably, if you do those things, you are more likely to succeed than not. Now, in my experience, the common reasons why planning applications become contentious, they begin with politics. Often there are issues of overdevelopment. There are environmental concerns. There are transportation issues. There is often a necessity to do a proper community impact analysis and understanding. There are policy issues at times. Now, the existing development mix could be a concern for the local authority or for the locality. There are infrastructure issues. There are public services to be considered. There is, of course, public opinion, which is interrelated with politics. There is the economic value, matters of sustainability, amenities, and then heritage issues. These are just only but to name the issues that you encounter. Now, commercially viable consent should be won before you submit your planning application. In other words, as I said earlier, you should anticipate the issues that are likely to arise and prepare yourself for dealing with them. So if you were working on a brownfield site, you will find that they perhaps are not as contentious as greenfield developments in certain cases. There are concerns of public perception that you have to take into account and deal with. You should also be mindful that if you're on a brownfield site, necessarily the site will need to be cleaned up. You will need to attend to contamination, particularly where you have ex-petrol stations being redeveloped. Of course, in that, you must think about how that impacts the bottom line of your profitability. And then there are, of course, the demands that the local authority will make of you in terms of Section 106 and community infrastructure levy. Now, conversely, on Greenbelt developments, you will find them to be highly contentious because there are pressures on the local authority these days to generate new homes. The government pressure on the local authority to produce land for development will be there. Now, there is, of course, the necessity to consider the balance between the brownfield availability and development land quota when you're looking to take Greenbelt. Now, converting Greenbelt land into development land is very contentious, and local authority may be reluctant to approve it. due to the political pressure that they're facing themselves. And the images that you see on my screen are in fact real images, as I'm sure we've all encountered, with objections to development of our Greenbelt. Now, objections to approve it, if there is no alternative brownfield to be used, if the local authority is not compliant in producing the development land quota that's been imposed upon them, then you may well find that the Secretary of State could step in and override them. You should consider also, when you're looking into the Greenbelt, whether you are looking to rezone a particular area for a development which it was not intended for originally, or are you actually dealing with a particular use that is there that you might wish to change, and that may be able to assist you. Now, I have an example of a matter that is actually still live, but I believe I've done justice in redacting it. It is a classic inquiry that came into chambers, and it was brought, of course, aimed at me. Now, as it says there, and I'll leave it on the screen. Now, this unfortunate client has been just served with a breach of planning letter from a local authority, a council that, of course, we, for confidential reasons, have had to redact their name. The email confirmation from their solicitor, my client said, confirmed that there is no restriction and no application is required for a change of use. Now, the email from the seller's agent confirmed the current use of the site. They gave us the title deed. The survey report, the valuation report from their bank even identified these things. Now, what this client is complaining about is the council has now requested for them to stop the development that they were doing forthwith, because it constitutes a breach of the Time and Country Planning Act 1990. The client says that we are unable to do this, as this will stop all our operations and stop our business, as our fleet of operation license has been granted at this address, and we have lorries operating from this site daily, and we have no other location to move our works to. The yard as it stands has been concreted over 95%. And I need to pause at this point and say that this matter was in the Greenbelt. And of course, all of you would be aware that one thing that the Greenbelt does not like is mass concreting. And this particular large piece of land is now at this point being concreted over 95%. The request was, could you please try and deal with this as quickly as possible? First and foremost, to buy time to resolve this, as stopping the operation will have severe impact on their business. They're also unable to restore the site to its lawful condition, which was a requirement of the planning notice. And of course, the last paragraph say, how can we proceed and what will it cost? But leaving all of that to one side, it's a classic of what you find. And I pause at this stage to say that my intention is not to go through, might I call it, Greenfield Planning Application 101, because I assume that most of you in my audience who are professionals really au fait with this. But if you have any specific questions in that regard, when we get to the Q&A, please do not hesitate to ask. I intend to concentrate on the issues that arise and how those problems are often dealt with. So in looking at this difficulty, it was easy for me to recognize that there were some fundamental difficulties. Unfortunately, a large sum of money has been invested in the acquisition and the development of this property, as it seemed, on legal advice. The solicitor for my client, as well as the solicitor for the bank, did not recognize the necessity for planning. Large sums of money was lent, and development was very well advanced, and in fact, part of the site was already in use. Now, rather unsurprisingly, when this notice was served, as I'm sure most of you will be aware, when the local authority serves you with such a notice, they will also serve it on all the parties with interest on the land. Of course, the notice was also served on the bank. The bank's reaction was immediately to fire a notice off to my client of their intention to call in their loan, because it's become apparent to the bank at this stage that the development was unlawful. Of course, the bank itself is prohibited from lending money on unlawful developments. Now, you sit back and reflect upon it, but the bank and the developer client went into it together. It's gone wrong now, but the bank, quite rightly, wants to call their money back, and is for the developer to pick up the pieces. Anyway, in picking the matter up, we engaged with the local authority in the first instance and decided to secure, for a start, that they will hold all further enforcement action so that we can get the opportunity to appraise the matter and then be able to advise our clients as to what the next steps were. I'm delighted to say that the local authority, of course, listened to that, because, of course, if they didn't, one could then take further legal steps to compel them to give reasonable time for the matter to be dealt with. When the local authority gave us the time, we were able to sit back and analyze what has been done. It was self-evident that the original advice which the solicitors, both solicitors had given, on which the development commenced, were in fact flawed, and that clearly planning needed to be addressed. So we reverted to the local authority to agree with them that there was a necessity to deal with the planning issues. Now, if one was then to revert to deal with the whole thing comprehensively as one unit, I was left in no doubt that it would have been rejected outright. So what we resolved to do on that occasion was to break the site down in terms of what works had been done already. So pretty much putting a project management idea to break the thing down into work packages. So broke it down into its constituent parts. And we decided to begin making retrospective planning applications on item by item. So for example, in the Greenbelt, we were able to revert and make a retrospective planning application for the fencing, just the fencing. The matter was debated, local authority were persuaded, planning consent was granted for the fencing. We were able to, or I was able to visit the site to be able to survey what was there before based on photographic evidence, because we were able to identify areas of mixed tarmacking, concreting, and other pavers. We were able to demonstrate and persuade the local authority that the element of concreting that had been done so far amounted only to marginally more than replacement of the old and decrepit with the new, and supposedly the more acceptable. It was a slightly protracted debate, but in the end, the local authority accepted my argument that, in fact, planning should retrospectively be granted for the concreting, which was the most offensive item. We secured retrospective planning consent for the concreted area. In fact, by the time this debate was going on, the client who couldn't stop with his ready-mix concrete had completed 100% reconcreting. So suffice it to say that we were able to go item by item by item, and largely we have secured a series of retrospective planning consents for individual work items, such that collectively there is now no work on the client site that has to be demolished and removed in order to comply with the original notice of contravention. So we've now moved on to the next stage. We've now engaged the local authority in a pre-planning exchange, because we're going back now to seek a change of use consent, which is what should have been done at the outset, in order to convert this otherwise existing use to a different use class. You all will be familiar with the use classes. And I seem to recall from the diary that the pre-planning meeting is scheduled sometime in the next week or two, and hopefully we will be able to take the local authority with us, because we have now demonstrated and shown them, if you like, consistent persuasion that they can approve sections. So we've built a reputation with them that we can actually be trusted in order to move it forward. So hopefully our client will secure the change of use that they're looking for. Now, one of the things that struck me that we're going to be using here is that not too distant from this site, driving, that is to say, rather than walking, there is a British Airways distribution center, which we're now going to use, hopefully, as precedent to demonstrate that we may be able to secure the use of this site as a distribution center, which will, in essence, enable our client to revert to where he would have been at the outset. Now, I make this point, or use this example to demonstrate that when planning objections come and notices are served, there are various ways of approaching it in order to be able to get a satisfactory solution. Now, that is me doing a whistle-stop tour, and I'll get on to Section 106, and all of you will be familiar with the Section 106 of the Town and Country Planning Act, as amended by the Section 12 of the Planning and Compensation Act of 1991. That amendment is a significant amendment, and this is why I cite it. Now, Section 106 agreements are legal agreements which binds the council, the developer, and any other parties that may have an interest in the land. So if you have funders or lenders with charges secured on your land, they will be impacted by this Section 106 agreement. In fact, it is often an express requirement for them to consent to it. Now, the objective of a Section 106 agreement is to regulate development and make it acceptable. The big question is, acceptable to who? Now, it's important to be aware that there are legal tests that every Section 106 agreement ought to meet, must meet. It must be necessary to make the development acceptable, and one will deem that to be acceptable to the local area. It has to be directly related to the development. It must also be fair and reasonable in scale and in kind to the development. Now, I stress that point of it being fair and reasonable in scale and kind to the development. Now, the significance of that is that clearly, Section 106 is a means of a planning gain for the local authority. Now, there has to be a degree of proportionality for it to work. The local authority cannot take too much from the development such as to render it unviable. Now, it can be a financial or non-financial contribution. In other words, you may have to build something in return for getting your planning consent, or you may have to pay a sum of money to the local authority. Now, question often arises is how many people are aware of how the local authority calculates what they are demanding of you in their Section 106 demand? Now, it's important to be aware that Section 106 agreements is non-standard. There is no defined standardization for Section 106s. The significance of that is that, in essence, you actually, in Section 106s, you get what you can negotiate, not necessarily what you're entitled to. And that is a very important point. But another key point of Section 106 is that it must directly benefit and be relevant to the area in which the development is situated. So it will not be appropriate for the local authority to take returns from Area B, Area A in development, and then apply those funds in Area C. Now, the facts are actually that is often the case. That is what they do, but that's not what they should be doing. And the developer and or parties with interest ought to be alive to this and can use that as a basis for challenging the validity of Section 106 demands. Now, I give another example here. A client came to us after a Section 106 agreement, which included an overage clause. Now, you probably be familiar with overage clauses. Now, in that, the value of the development, if it increased above what at the time they did the deal at £450 per square foot for resale value, and the local authority wrote into the Section 106 agreement that if sales were to increase and be over £450 per square foot, then the developer would be entitled to pay the local authority 20% of the uplift. So that's an overage clause. So you give us this for now. Should it increase any further, we share with you in those increases. Now, when the developer was completing the development, he was getting offers of the order of £650 per square foot. You can see a £200 uplift before the development had completed. On that basis alone, the local authority were due to receive an extra £2 million. Of course, the developer's solicitor has advised the developer there's nothing you can do. That's what the agreement says. You pay the local authority $2 million. And of course, the prices were still rising. And the likelihood of that $2 million increasing was going up and up. Now, the developer, who was rather uncomfortable with paying that extra over and above what was agreed, engaged us to look at the matter again. We engaged with the local authority on it to challenge the subsistence of that overage clause. In many cases, people who don't understand the constituent parts of a Section 106 would agree and pay. However, there is room always for negotiation, even when on this occasion the agreement was actually locked in, settled, development was nearing completion. We were able to demonstrate that what the overage clause actually addressed was only the uplift in the valuation that the developer was achieving. What the overage clause omitted to do was to consider the additional costs of the development, which the developer may have suffered in the intervening period. We all know what happens with construction inflation. And given, if you recall what I'd said historically about the proportionality, the necessity for the value in both scale and amount of the Section 106 demand to the development, we were able to demonstrate to the local authority that the overage clause on this occasion dealt with the valuation, the profits only, and not the costs. And that when that was factored in, it was our opening gambit that the overage was actually negligible, that they should be receiving nothing. Suffice it to say that was where we started, but we concluded with the conceding that they should be receiving £180,000 instead of a £2 million return. And I think I seem to recall that our developer client on that occasion was rather pleased with the outcome. So I've touched upon objections. Now I've touched upon how one deals with these issues when they arise. Now there are planning objections and appeals. I don't intend to dwell too much individually on this, but what you should actually be aware of that dealing with planning appeals often takes typically 24 weeks. And if you are a developer, you might wish to consider taking appropriate steps to save those 24 weeks if you can by dealing with it at the outset. If you deal with it at the outset, you're more likely to be able to get a result that will then avoid the issues taking you to appeal. So This is me doing a rather rapid run through and summary of it to ask you then, if you have any contentious planning issues that you would like to raise in the Q&A, have no hesitation in raising those. Now, I will be able to give you indications of how I might be able to deal with it, how we might be able to think about it. I wouldn't be, of course, able to give you a detailed answer in a forum such as this, but it will give you an opportunity to raise issues, get initial ideas, something that you might wish to work upon yourself, or something you might wish to set aside time for us to look at it in greater detail. So in summary terms, those are my presentation. It's over to you for your questions and answers now.
Samuel, I believe there are quite a few questions on the chat.
Right. If anyone can fire away with any one of them, I will be only glad to attempt to answer them.
Well, I've got one.
Okay.
As a legal advisor, can you predict which issues you can overcome?
That's a very interesting question. Which issues I can overcome? I suspect that there are very few issues that we cannot overcome. The significant thing here is actually to think outside of the box. Clearly, when issues come to you, it's because there are people who feel strongly about it. You want to understand why that is the case and be able to utilize empirical evidence to revert, hopefully, with a better argument. And as I've given you in my presentation, a couple of examples where quite clearly there's been a prohibition notice. You are building without planning consent on a greenfield and you're doing developments that would not otherwise have been approved. If you sit back and look at it, it's not an easy objection to overcome, but we devised a methodology for getting the answer. And on the other, you have an agreement that is signed, sealed, and delivered. You have to pay us £2 million. Pay it. But we were able to revert and challenge it. So I'm not saying that we can answer all the questions, but I don't think that there are problems that have absolutely no answers. It's a case of how much you're prepared to invest in trying to devise a solution to those problems. Does that answer you?
Yes, it does. I got a few more, but I'll give the chance to other of the participants to ask, and then
okay, fair enough.
I'll fire away.
Okay. Oh, by the way, anyone who wishes to ask a question, feel free to unmute themselves and then go ahead.
Hi, Samuel, it's Jermaine. If you hear me. Hi. It's related to the first example that you gave, and building on Greenbelt. Not knowing, obviously, the full details of the size of the plot and exactly what was being done, to me, it sounds like the fact that concrete, and probably a substantial amount of concrete, was being used would suggest to me that you probably would want to engage with the planners. However, what led the two solicitors to come to the conclusion that no planning inquiry would be required? Obviously, you reached a completely opposite conclusion, clearly the right one. And obviously, not being a solicitor, I probably would have come to that conclusion as well. But two other trained solicitors didn't. What was their thinking, do you think?
I must say that as unique as it sounds, you will actually find that when you get into the High Court, which we do day in, day out, to my mind, and forgive me if there are any solicitors or relatives of solicitors that are here, often not as great depth of thought is given in certain pieces of legal advice. That is why parties who've spent money fall out. Because the solicitors who were involved in this case are potentially facing professional negligence attacks on them. Far be it for me to wish to comment on whatever would have led them to. But in reality, these people were more, might I say, versed in conveyancing and in financial services rather than in town and country planning like you and I. Now, I think the necessity is for them to realize when the matter is beyond their scope of knowledge or expertise so that they can seek proper advice. So, for example, I have some solicitor clients now who, if they're invited to draft Section 106 agreements, will invite me to draft it for them. Because they say, look, there's so much that goes into this, that's not our expertise, please do that for us. And they will charge that as disbursement in the course of what they're doing. But what would have led them in this case, I simply don't know, but they did. And both their clients were in serious difficulty, but I'm pleased to say that we're helping. But on many other matters that I'm dealing with, sometimes you find that you're struggling to save the skin of your professional client as well as those of your lay clients. Yeah. So, Jermaine, I'm sure, I mean, you would have reached the same conclusion as I did, but I couldn't tell you what possessed them to advise as they did.
And sorry, just one more, based on what I just mentioned, would there have been any recourse on the architect at all? It doesn't sound like there would have been, unless there was any advice specifically asked of them. But would there be a chain there?
Yes, there will be. There is a potential chain.
Right.
Yes, there will be a potential chain because generally it depends on how contentious the client is. There are certain clients, when things go wrong, they look for everyone to attack. And it wouldn't be unreasonable for them to revert to their architect and say, oh, why didn't you tell me? Now, the question will arise from if I was advising the architect, he said, what were you asked to do or not to do? But it will not be unreasonable. It will not be entirely unheard of for the architect to be asked, why did you not tell me that I couldn't do this?
Yeah.
So architects in the main, as lead consultants, should always, to my mind, be able to advise their clients, shall we sound someone out on this? Now, once you have raised that issue with your client, saying, why don't we just get a short opinion on this, even if it's a 1-hour consultation with a specialist on it, if the client says, no, we don't want to do that, we don't have time to do that, now you've discharged of your own obligation to advise him or draw his attention to it. Now, if you then did take the advice, so if your client did take the advice and you had a consultation, I'm sure counsel will tell you, yes, you definitely do need advice. You do need planning on this. And if in doubt, when I could approach the local authority and say, we're doing this, we don't believe we need planning, what do you think? I'm sure the planning officers will immediately tell you, no, you do need advice, but you do need planning application, make one. Okay?
Yes, thank you very much.
Now, David's hand is up on the, from what I can see on the screen. David, do you want to unmute yourself and fire away with your question?
Yes, thank you very much. I just had a question in relation to the amount you saved on the overage. If I understand rightly, it was originally set at 2 million and it ended up being 180,000. Is that correct?
Yes.
Was that sort of if it was formally locked down through a Section 106, was that sort of adjusted through a deed of variation?
Correct. You got it all in one.
Yeah. I just had a query. Was it, because if it's locked down and obviously the positions that councils are in, you know, they want the pound of flesh at the minute. Yes. Was it a sort of, did the client run a viability argument? Because obviously you said about talking about the uplift in build costs over the same period as the overage. I just wondered what sort of angle they looked at it from. Did like I said, did they run a formal viability appraisal? Because obviously the counts,
David, you ask a very good question. The local authorities, when you make a planning application, they do their viability assessment. They often retain a consultant, or sometimes they do it in-house. But largely, they retain a consultant to do a viability analysis. And the viability assessment is what they will present you with, which says that you should pay 2 million. Now, what all of you professionals should appreciate that when viability analyses are run, there is often what I call a maxima and a minima allowance. There is a band within which Section 106 can cover. Suffice it to say that many are unaware of that. The local authority will always approach you with the maximum amount that they can ask you for, and then step back gradually from there, depending on your own ability to counter them. Yes, part of the argument I ran was a reevaluation of the viability analysis, and then returning to the necessity for any Section 106 agreement to be proportionate is the concept of proportionality. Now, although the original amount seemed proportionate, the overage made it incredibly disproportionate. So if you look at it, the local authority are not participating in the development risk, but they are sharing in the development profit. But in essence, my interpretation of the effect of that clause was that it became so disproportionate that all of the cost increases were to be borne by the developer, and all of the profits were to be shared with the local authority. Now, that doesn't sound right, does it? If you've got to share in profits, you've got to share in the costs. And let's face it, the top slice will be squeezed if the costs are rising, albeit if the costs are going up and the value is going up, then there is a slice that is moving. So what we were able to demonstrate is that first and foremost is to get local authority to concede the proportionality argument. And once they've conceded that, and we had detailed evidence backed up with facts and figures and calculations, and I must say in that case, that is where the good old profession of quantity surveying came into play. We were able to put together enough to persuade them that if it's going to remain proportionate, then we should factor in a lot more, and then we needed to vary what was agreed so that what was paid was less. So that was part of the angle. But then, as you know, it's not a one-size-fits-all. It's looked at on a case-by-case basis. So it's a case of identifying where difficulties were and then being able to devise a solution to the problem.
Thank you very much. And just a final one. So I assume that when you ran that argument, your client hadn't actually started on site by that point, because sometimes we find difficulty when clients are experiencing greater costs, but they've started already. It makes it a little bit more difficult.
You will actually be surprised. The development was well advanced.
Oh.
Yeah, that's it. That was one of the things, because once you start on site, they say, well, it's locked and you can't move. But imagine that you find yourself in a position now that construction materials are not readily available. There are nationwide, well-recognized haulage issues, all of which increases costs. And yet, you're locked in a position where those costs cannot be absorbed. It can turn an otherwise viable development into an unviable one. But if you're able to maintain the viability of it, but wishing also to bear down on the costs that are controllable, because the local authority will stand to lose a great deal if the development was to fail. And as such, we were able to bring that together. So it's usually quite difficult, but we delight in engaging them and reversing it.
Thank you.
Good, pleasure.
Samuel, we've got quite a few questions about the concrete example.
on the Greenbelt, the classic.
What I'm going to do is I'm going to read you three together, and hopefully, so with all the concrete on the site, it doesn't sound like Greenbelt. I presume there's been traffic studies on the site, environmental assessments, and some mitigation works. Question. Then the other one, sounds like a major development in which the client proceeded without planning permission. Is this so? And then Jessica's asked, if a section 106 is agreed to at planning and then taken on by a developer, once work has commenced and planning conditions approved, is it possible to justify that the monetary value of the section 106 money required to pay is unreasonable?
Okay.
So, concrete, did they do any prep works or assessments? And did they proceed without planning permission? And can you unpick, my layman's terms, can you unpick a section 106 after you've started works?
Okay, first question, the answer was yes, they started without planning consent and without all the assessments. Guess what? Because they were advised by solicitors they could. Are you with me?
Mm-hmm.
Now, so that answers that one. What's the second one?
The second one was they proceeded without planning permission. Did they?
Yes, they did. That's why the local authority were obliged to then serve them with their notice to stop.
Sir, I'm an architect and a planner. When you study architecture,
Sorry?
when you study planning, you study planning law. I mean, I still can't believe that something like this can happen. This is a major development in a very sensitive area, the Greenbelt. I get inquiries like this. And the first question, is it in the Greenbelt? It's one of the most difficult areas to develop. What about the, when they went, okay, so you escape planning, how about building regs? When you fill in forms for building regs, they ask you, have you got planning permission? And they do speak, the planners speak to the building regs people and vice versa. Where there has been zero communication, I still can't believe this. I keep on telling myself that probably I misunderstood. I didn't get the picture correctly.
Mr. Farage, you did not misunderstand a thing. And that is why I use such exceptional cases in my examples in these webinars. Now, when you receive the brief, you sit back and ask yourself, oh, is this really happening? But you have a well-heeled client. I mean, you saw the the initial instructions that I received, which was only redacted to remove names to make them, if you like, anonymous. Yes, it does happen. You are a professional. You can see that in that matter, at the outset, there was no planning consultant, there was no architect, there were the professionals they had were two solicitors. Now, they proceeded to borrow and the bank proceeded to lend and they commenced work. It's a real life, reality. And you sit back and ask yourself, how could it happen? You're quite right. The surprises you express is perfectly in order, Mr. Farage. Am I right? That's Mel Farage, correct?
Yes.
Indeed.
What kind of project is this? How do you start without what? No drawings, no structural drawings, no?
No, they had drawings, but it happened. Mind you, the issues arose when they purchased the site and began development. So they came prepared, and that is why one of the questions that I had earlier was that are there implications for the architect there, although the issue is not addressed. In my presentation, most reasonable architects, as I advise them, will be perfectly in order to tell their client that notwithstanding what they've been told, that certain things should be checked. And yes, an hour's consultation will tell you with someone like me, irrespective of what your solicitors told you, there will be a breach of the Town and Country Planning Act 1990 if you proceed without these. And you must go and put them in place. And if in doubt, just turn around to the local authority and they'll tell you themselves. So you're quite right. Sorry, the question that I was answering before Mr. Farage answered, did I deal with those all right?
Yeah, they were fine. We've got a couple more. So we've got Jessica's about, effectively, can you unpick a section 106 after commencement and planning conditions are approved?
That is consistent with the question that I dealt with earlier. The prima facie position is no, unless there are circumstances justifying it. It depends. That is your classic, my classic answer to that. It depends. It can be, depending. It's not open for you to have signed an agreement today, go back tomorrow and say, well, I was uncomfortable when I signed it before I got planning, and I now have planning and I should revert. Now, there are circumstances which may cause you to revert to them. Mm-hmm. Okay, if that answers it.
Yeah. Bob's asked, how do you account for the disparity between the long in the tooth planning policies and rather vague emerging policies? Both often being used to say no to an application. And then he says, local plans are invariably bedded in the past, whereas we're all trying to build for the future.
Correct. Well, I think that is a conceptual point that I can almost spend an hour on, but let me refrain from doing so. But to say, yes, it's an angst that you have such issues, but on a development, one can actually make a particular case on a particular development on why it should be advanced with. But of course, I can talk more specifically if I know the details of the particular planning applications, rather than as a general point, I share the sentiment expressed.
Okay, so we've got a continuation from Jessica's question earlier. We have a scheme that has previous consent, market sale submitted by the landowner with 400k section 106 contribution. We're looking to deliver 100% affordable housing on this site and wondered if there have been any previous examples where the local authority has rewritten the section 106, given the affordable provision being made, and how long does this process normally take?
Okay, this is a matter that requires a particular consideration on its facts, because what I hear there is that the development is 100% affordable development.
Yeah.
If it's 100% affordable development, question mark, why do we have a 400K section 106 demand on it? It shouldn't have, to my mind, at the outset, but that notwithstanding, it requires a particular examination. Now, remember that the object of a section 106 is to benefit the development. So in other words, what is that 400,000 to be spent on by the local authority if we're providing all affordable homes? It may be other recognizable facilities to support that development, but that money must not be used to solve a problem which pre-existed the development. Am I making sense on that? Yes. So the job of section 106 is not to provide money for the local authority to right the wrongs that pre-existed the development. Okay, I have a hand up with NE55 iPhone. Can you hear me, NE55 iPhone?
Don't know if they can hear. I've got another question here, Samuel. Just
okay, fire away.
I currently have a project where we submitted.
Oh, sorry, Samuel.
Oh, okay. NE55 is away. Hello, NE55.
Oh, yeah, sorry, I couldn't unmute myself, Samuel. I'm so sorry. It's Tony.
Tony.
It's Tony.
Tony, what question do you have?
Samuel, the question I had really related to just very special circumstances, especially in relation to use on the Greenbelt.
Okay.
And in particular, we had previously been embarking on a development using VSCs for development on the Greenbelt, which is also part of an area of outstanding natural beauty. And it was to formulate a housing proposal which would as part of it, dispense with a non-conforming commercial use on the part of the land.
Pre-existing
commercial use on, say, about 25% of the area, and saying, can we develop all of the area for housing, provide social housing, and the VSC was also to provide a large community benefit in terms of some community buildings.
Mm-hmm.
What's happened more recently is that commercial land has gone absolutely crazy in terms of its value.
Correct.
So what started off perhaps 2 years ago when we were having discussions with the planners about a housing development that provided a viable solution is now probably tipped where actually the commercial land value now is worth almost as much as the land value with the planning consent would be worth if we redeveloped it. And I'm just wondering whether there is some thought about, could we still go back and say, well, look, actually, what we'd like to do is develop 50% of the land. Rather than going for 100% of the land for housing, we'd like to develop 50%, but we'd like to develop it for continued commercial use, but still give you all the community benefits. So enough development to provide enough funding to provide the community buildings that were always going to be built. And I just wonder whether, you know, this notion of perhaps using VSCs for commercial use, whether you felt that would have any support or could be even an argument that's put forward as opposed to a residential use and dispensing with an otherwise non-conforming use. I don't know if I'm trying to make myself clear, Samuel.
I think I get the gist of the challenge behind your question. And my thoughts are obviously racing up and down. It strikes me you have a pre-existing non-conforming commercial use, and there is the intention to remedy that non-conformity with a larger residential development and community benefit. And now valuations is causing you to think otherwise. In all honesty, I think that matter deserves greater attention outside the forum that we have this evening.
Yeah, no, I understand. It's complicated. I wasn't sure whether you'd seen commercial use being used as part of very special circumstances, you know, in some of your work in arguing. Yeah.
Yes, and I think also that perhaps you need to formulate, you need to decide for yourself what you want to achieve, 100% residential or 50-50, and then make the case for it. And the local authority are open to be persuaded rather than the shutters coming down. But I can quite happily set some limited time aside for us to chew that fat, if you rather, outside of this forum. Because it may not matter that catches widespread attention for other people.
No, I totally understand. I think the point for the wider audience was around the fact that actually residential development right now versus commercial development is a very fine balancing act.
It is.
And what was originally let's convert commercial into a residential, and that's you know, a viable scheme. Now I think the balance has almost tipped the other way, that a lot of commercial land actually has a lot more value, and I wonder how that's going to affect residential development going forward.
It will be a crush, no doubt. People, you see, money will always follow returns. And if it is that commercial valuations are going up, investors will go for it, and therefore there'll be lesser provision on residential. But as you say, it's still finely balanced, but you can see the direction of movement, can't you, Just?
Mm-hmm. Yeah, absolutely. Samuel, I'm happy to take that offline with you, of course, as well. So thank you very much.
Okay, it's a pleasure. All right, I have more questions.
A couple more.
Yeah, sure.
So somebody has a project at the moment, Georgina. Somebody submitted a sworn affidavit relating to the previous use of a Greenbelt site, and subsequently a group of objectors have submitted a statement to counter this, claiming it to have also been written by the same person, which is denied by the person. So the question is, The council are failing to respond as to whether they will give any weight to the second statement. So they've had one statement saying it was used before and another statement saying that's not true. How will the local authority handle that, and how would they deal with the fact that there's a counter statement which they don't believe is accurate or true?
Okay, well, put it bluntly, how the local authority will deal with it will starting point will be their own local politics. More to the point is that Georgina, what side of the fence is Georgina on the wanting to rely on the first statement or wanting to rely on the second statement?
She has a first statement saying it was previous, there was to a previous use of Greenbelt. Right.
Okay. So what she wants to do, to all intents and purposes, is to succeed.
Yeah.
Right. And her success, I think I have a lot more. I know it's a one-sided question that she has written, but I'll ask her more questions to tease out greater answers as to what one can do to then get the local authority on side. So you want to get the local authority on side where they will be making the decision willfully that you want them to make. And sometimes you may have to show them that if they didn't make that decision willfully, you're capable of making them make that decision willy-nilly, in which case they will prefer to do it willfully now. So I need to know a bit more about what the issues are. It's a case of whether or not Greenbelt is being used. Yes, there is a statement to that effect. So where does that take us?
Okay, Georgina, if you want to add some more into the chat or come off mute. Samuel, two other things.
Okay.
I'll ask it in a different way. Chris Mellett asked a question, but I'll ask it in a different way because I know how barristers react to this question. How do you work with people in the sense of, he's asked how much you charge, but I know you'll want to say
too little.
So how do you work with people? Is there any way that they can engage you for a review? Probably the easiest question. And then another question is, can you give more information on the community infrastructure levy?
Yes. Okay. What do we charge? My clerk will be delighted to always give an indication of what a particular piece of work will cost in advance before I become engaged in it. Can I be engaged for a review? Yes, I can be. I regularly am engaged in review work. Can I say a bit more about community infrastructure levy? Yes, it is a subsection of what you are actually being required to pay under the Section 106 provisions, which is supposed actually to assist with a piece of infrastructure. It's a levy that is made on, say, for example, you're doing a development where there isn't proper access. And if the local authority is choosing to expand the access to your development for the purposes of enabling your development to work, then they can make a levy, a reasonable one. I can go into that in greater detail and give several examples, but then I think it may well be specific to the questioner's circumstances for my answers to be valuable. I can give general answers to general questions, but ultimately people come to me because they have problems. There is a difficulty to be solved. The essence of these webinars are this. The legal profession generally come into play when problems exist in order to solve those problems. But what I'm also trying to encourage my clients is to anticipate these problems, because the costs of avoiding these problems far smaller than the costs of resolving them, if that makes any sense. Mm-hmm. I suspect that that's as much as I say about that, unless there are more to that question.
I've got another question. I don't think Georgina's come back yet, but somebody else has.
Okay, if Georgina comes back, by all means, I'll take it. Yeah, go for it.
Yeah. How do you account for the disparity between, oh no, I've done that one.
Okay.
There was one about, with development in Greenbelt, have you noticed inspectors dealing with the difference between the spatial and visual openness arguments in inquiry since the Samuel Smith decision?
Not very much. on any matters that I've worked on recently more specifically.
Okay, and then this one's come through privately, so I'll tell you this one, but I don't know whether you'll want to answer it. So what's the difference, and it's not a joke, Samuel, with you engaging with the planning department during the application versus after? Do you see any change in the way they approach applications when they know? How does that work? Is there any noticeable difference in the way they process an application?
Well, okay. If I may just try and understand that question better, who is approaching them? The developer, the architect, or Samuel?
That's what they're saying. Is there a difference with Samuel approaching them versus either the developer or, I assume, the architect?
Well, I am sure that there is a conventional, might I say, flowchart for dealing with planning applications generally. But I tend to find that when we become involved, the planning officers and their senior planning officers, probably take greater care in listening to the things we say and responding to us. I suspect rather, I think they see the name barrister, they then realize that we probably know what we're talking about, and that if we're not responded to appropriately, that we may well go the next step, or that, of course, if they make arguments that don't add up, we find it easier to knock them down and perhaps match them up with even better arguments. I mean, that's what one finds in daily work, that it is most unlikely that we take an argument to the planning officers or their seniors or to committees that get dismissed out of hand. Invariably, they show greater attention in giving us audience. And then invariably, I say, more often than not, conceding on what we are asking them. Provided, of course, we don't go and ask silly and unreasonable things, but where we try and represent our clients' cases, we tend to find that we get very commendable audience.
Another one that's just been sent to me from Fu on the other side, embroiling the Secretary of State in approving planning decisions. How often does it happen? How easy is it? And
it ought to be rare, but we have had instances where it's called in and then approved. There is that requirement for the local authorities to have zoned sufficient land to meet their quota, and the issue does arise when they haven't zoned and there has been an application made and is being refused. Then the Secretary of State will be entitled to call it in and then approve it. It ought to be rare, is the answer.
Okay. They're all the questions I've got. Does anybody else have any questions they want to ask?
I think David's iPhone, hands up on that. Patiently, sir. I think it's been up for a while, actually. Hello?
Sorry, that was left up in mistake. Sorry.
Sorry, that's okay. Okay, it was from the last time.
Any other questions from anybody?
And I've got a question about appeals. How much we appealed a case whereby in this street some development have occurred, numerous development. It was loft conversion. Yet in our case, the planners refused to allow us this loft conversion with the dormer window at the front.
I think your line is fluctuating a bit. Is that Mr. Mel Farage? This is a loft conversion,
yes,
where your planning application is being refused.
Refused. Yet there are many examples in the street of it was to do with a dormer window at the front.
Ah.
Okay. So we appealed it, and I gave the in my appeal about 10 examples in this tree of the loft conversions, all over with photographs, with numbers of property, the property number, and so on. Yet my appeal was not successful. I wonder how much precedence, how much weight precedents have in appeal cases.
Well, it ought to be a very significant weight. Now, as you were asking your question, I was racing through my head. I have recently, not in the distant past, dealt with.
Yeah.
This wasn't a loft conversion, but this was planning where the point in issue was dormer windows. My client's planning application was rejected because it was said by the planning officer that there were no dormer windows on the road, and therefore introducing one will change the character. Again, I paid a site visit and I walked up and down the street, and I was able to pick up one incident of a dormer window being on one particular property, which is substantially dated. And reliant on that single example, that precedent, plus a few other things that I threw in the mix, I was able to reverse it. And the building is built with 2 decent dormer windows, and it's there. So I'm surprised in your case.
I must have given the appeal inspector about 10 examples of dormer windows. It is at the front, and yet
how recently was that, Mr. Farad?
Probably 3 years ago.
Well, if you're still keen on it, it may be a matter that you might wish to revisit.
Well,
so you just think about it, because if you are telling me that, I mean, if you look at the appeal decision, it should set out why it was refused, and the appeal itself, or the primary decision, decline your application because of dormer windows.
Yes, basically. Yeah.
Well, such a refusal will be susceptible to judicial review successfully, I think. But I say so without seeing the details of it. But if what you say is that within the same vicinity, you have 10 precedents and you're being refused for that, then that doesn't seem, it's a decision that may well be seen as unreasonable.
It's unreasonable, but I thought the only way forward for us against the inspector is to go to High Court.
And that is where you do judicial review. But clearly, it seems to me that you, as I always advise every client, you need advice before you get into judicial review. I am presently dealing with a matter that has gone through the full run of appeals and got to the High Court and failed. And now it's come to me. Now, I have just looked at the transcript of what happened in the High Court, and they ran entirely the arguments that I didn't think was appropriate.
I didn't think it was appropriate, but my client gave up on the case. We stopped there, unfortunately.
It may be your client might wish to look at it. If they're keen on it, they can look at it again and probably take advice. But if they've given up on it, which is, I don't like people giving up on viable developments.
I think they have a good chance of success, but they can want to.
Yeah.
Samuel, we've got another question from Charles.
Okay, Charles, go for it.
Hi, thank you. It's a question relating to Greenbelt, and it's a site that I've got an interest in, which is quite strongly got possibility as Greenbelt infill. It's a missing couple of teeth in a row of houses. This land was actually going to be marked for removal from the Greenbelt under a local authority draft plan. It's a local authority that many people might recognise if I say that it's recently been challenged under duty of cooperate, fought back hard against it, and then got unified and effectively had to pull its local plan, and now is a local plan is starting from first principles under the unified authority. And my question really is, Greenbelt infill is one thing, but it will be quite limiting in what we can achieve in terms of the density of development compared with what we might have been able to achieve under the removal from the Greenbelt, albeit without an actual specific allocation. It was recognised that it was probably the only site within that release that would have come in for the windfall allocation under the HELA. And so what I'm trying to gauge is whether that, even though it was never sanctioned by adoption, and it never even got as far as being, that part of the agenda for formalisation under the examination, it was nevertheless part of the recognised last standing draft plan of that local authority before it ceased to exist. What weight does that have incrementally, if any, because I appreciate there's a question of whether it has any standing at all, in the, if we want to try and push forward with the local authority and not wait for what could be a very protracted draw out of this new unified local authority draft plan?
Well, the fact that it has once been considered within a draft plan is helpful. But clearly, as I'm sure you approve, because it's only a draft that didn't get far for an authority per se that no longer exists, will be the limiting factor. The question is, what else are you capable of adding to that argument to persuade the existing local authority to consider it in the meantime?
Yes.
I think yeah, there might be, depending, you call it the greenfield infill.
It's well, actually they made a mistake. Originally they had it as previously developed land, and then they made a mistake and had it marked down in the last draft as undeveloped land. We challenged that. They said, well, it's too late to change it now. But nevertheless, the land is earmarked for removal from the Greenbelt, so it shouldn't make any difference.
Do you have exchange of correspondence saying what you've just said?
Yes. And I also have subsequently put in a Brownfield call submission under the new call for Brownfield under the unified authority, and have sort of, if you like, cleared the site so that there can be no being subsumed into the landscape argument, because it was quite a hairy This
is a preemptive move.
Zero.
Okay, fair enough. Well understood.
So we've got a site which has got numerous outbuildings, one dwelling, 2 consents on it for redevelopment for a much larger single dwelling, and the piece of land adjacent to it has been acquired, so that it is actually all formulating a package. And there are some minimal structures, but nevertheless some structures on that site. So collectively, we're saying that it is potentially Brownfield site.
I think you had a case. You had a case to make.
It's all been fenced off and at the back with sort of chain link, and at the front with Harris. So it's quite clearly saying building site, develop me.
Yeah, you clearly have a case to make, but it's probably for me to be able to give you any valuable material guidance. I probably need to see greater details and have the opportunity to ask you more questions than you probably would like to face in a forum like this.
Sure.
Because unfortunately for my clients, I ask you the most incisive questions and draw out all the things that I need to build the best possible case for you.
Yeah.
Okay, but maybe something we can talk about subsequently if you're that way inclined.
Okay, thank you.
Good.
Samuel, we've got Georgina's come back.
Okay.
And we've got another question after that I've got to come to. So Georgina came back and said, basically, she's acting as a planning consultant for the landowner on a previously developed Greenbelt site. They have a sworn affidavit from the previous occupier, and objectors have since prepared a statement saying the opposite, claiming it was made by the same previous occupier. And so now there's two alleged statements from the same person saying the opposite. They've spoke to the previous occupier and does not remember the statement. And they want to know, how do they argue the fact that they've got, effectively, the local authorities got two sworn affidavits from allegedly the same person, one saying it was used previously and one saying it's never been used?
Okay, straightforward answer. I think Georgina needs to take a quick step backwards. She's not interested in the statement that she considered to be contrary to what she's saying. She says she's spoken to that previous occupier. This is a straightforward conflict of facts, which we determine every day on the evidence. And so long as we are content that we have the right evidence, we'll beat the old one, which is being put together by third parties. So it's something that requires specific attention. If you can communicate that to Georgina, it's a case of actually articulating your case and being able to put your own evidence, which is material and supportive, superior to the other.
Okay.
We still have many more questions left. I'm mindful that we are overrunning by about half an hour, and some people might wish to leave early. But go ahead.
One more. So, what's your opinion of promoting a site that was once allocated by the council but has subsequently been removed from the local plan, particularly given that the council will fail to meet future housing demand?
That's quite interesting. So it's once been allocated and then been removed, and they're still not meeting their objectives.
Yeah.
What's the scale of the development? Do we know?
I don't think we know, no.
Yes.
Okay.
Well, I can tell you it's 1,600 units.
Well, that requires greater attention.
Okay.
It does require greater attention. I think you've got some persuasive elements to it, in and out, and still not meeting objectives. What is their reason for not wanting to go forward with it? Do you know? Has anything stated?
Yes, because they now have a new policy that they are not going to be supporting developments on the existing local area boundary or into adjacent villages.
Doesn't sound very reasonable a basis to decline. That's perhaps something I need to ask you a few more questions about it again, in order to be able to articulate the best way forward. Because it's been in first and been taken out, and the key thing is that they are failing to meet their quota. I think that gives you strong ammunition to push harder, and there's a sizable development that is coming there.
Samuel, Fu's going to put the email address of the office into the chat.
Okay.
There's a few people where you've said that you probably need to take this offline. So you've got to disappear. I've just got a notice that you have to disappear, Samuel. So
yes, I'm keen. I think I wonder if there is anyone who's been raising their hand for a while that has not been responded to.
I can't see anybody. If I've missed anybody, apologies, but I can't see anybody else.
Okay, right. So otherwise, I'm grateful, and thank you all for attending and remaining attentive, and then having all these questions. By all means, as I said, as just been said, our email address will be on the chat subsequently, and if there are any further questions that require attention, please have no hesitation in advancing them, and hopefully we will continue to resolve the problems that come in this regard. So thank you very much, all of you. My pleasure. Okay.
Thank you, Samuel.
Okay, thank you. Bye-bye now.
Bye.
Thank you.